This will be the second day of testimony in the murder trial for a former Grand Rapids police officer. Christopher Schurr faces charges for shooting and killing Patrick Loyola during a traffic stop 3 years ago. Teresa Weekly is at the courthouse with a legal expert with what we can expect today. Teresa?
Good morning, George. Things are still relatively quiet here in front of the courthouse. A few people have showed up to show their support for former officer Christopher Schurr. As far as what's going to happen today, we expect to hear from more witnesses for the prosecution. They have 3 more to call. Now, in court yesterday, they already called 8 witnesses, and they really focused a lot in some of that testimony on the taser. There was a struggle over the taser. The prosecutor was looking to show that because it had already deployed, it was not posing as much of a risk, and that is really coming into play in terms of the defense trying to prove that Christopher Schurr had a reasonable fear for his life, and the prosecution trying to prove that he did not. Now, we have Peter VanGelderen with us this morning, who has been a lawyer in criminal law, criminal defense in Grand Rapids for a long time, since 2009. Thank you for joining us, Peter.
Yeah, thank you for having me. Happy to be here.
So, in looking at what the prosecution's trying to show with some of the testimony yesterday with the taser, how effective is it in terms of what they've done so far to prove a lack of reasonable fear?
Well, so an important thing to keep in mind regarding self-defense is once a defendant makes an initial showing of self-defense, it's actually up to the prosecutor to prove beyond a reasonable doubt that they did not act in self-defense. And so what you're seeing from the prosecution is through each witness showing the lack of urgency and threat, I think, to life. Mr. Butler's testimony describing the incident and then discussing the discharged taser as well to show that that level of threat wasn't there for Officer Schurr to have to use deadly force. So that's what they're doing right now.
How important was it to you that they discussed and focused on the taser already being deployed and that you can't redeploy those prongs and they would only be able to use it as a stun gun at that point?
Well, I think that's really critical because, as the prosecutor pointed out, and I think they referenced in their opening too, that the officer knew that those had been discharged and that there weren't any charges left. So to me, that is what the prosecutor is trying to do, is to show that that threat has already been gone, and therefore the taser is not as threatening to the officer as he may believe, in an effort to overcome that burden that they have with the self-defense.
You work in defense, so what does the defense need to do at this point when they call their 40 witnesses?
Well, I think what you're going to start to see is a lot more technical testimony here, expert testimony, and they're going to have to show he was acting, and we already saw it in their opening statement, acting in self-defense, consistent with his training and experience, consistent with use of force techniques, and to show that that was a necessary act by him. But I think it's always important to remember that defense doesn't have to prove anything. And so that's why it's important to understand that self-defense burden, that still rests with the prosecutor, even though it's a defense to the act.
Thank you so much, Peter. And we might rely on your legal expertise as well as this trial continues.